In the art world, Tyrrell Winston is known for transforming the remnants of playground basketballs, deflated, scuffed, and worn, into striking fine art installations. His sculptures, made from found basketballs arranged in precise grids, have appeared in galleries around the world and have been licensed by brands like Nike, Adidas, and even the NBA. But now, Winston is suing the NBA, specifically the New Orleans Pelicans, claiming their team copied his distinctive artistic style by creating and posting a grid of deflated basketballs that look strikingly similar to his work. I'm Scott Hervey, a partner with the law firm of Weintraub Tobin, and today I'm joined by my partner, Richard Buckley. We're going to talk about Tyrrell Winston versus the New Orleans Pelicans and whether this case, like the Sidney Nicole versus Alyssa Shield decision, marks another step towards protecting an artist's style under copyright law. On today's installment of The Briefing. Richard, welcome back to The Briefing. It's good to have you. It's been a while since we did our multi-part series, so it's good to have you back.
Been a while, but it's great to be back.
I'm glad to have you for this one. This one's, I think, interesting. Let me ask you: Are you an art aficionado, Richard?
I wouldn't say that. I do appreciate good art, and but no, not an aficionado, I wouldn't say.
Okay. Well, there's some art that we're going to talk about in this story that I'm very curious whether or not you saw this installation or not. But let's get into it. Let's get into this case. So let's start with who Tyrrell Winston is. So according to his complaint, Winston is an internationally acclaimed visual artist recognized for his distinctive 2- and 3-dimensional sculptures of deflated basketballs arranged in precise grid compositions. He has spent over a decade collecting old basketballs from city courts, flattening them, and organizing them into orderly, well-mounted arrangements. Each piece tells a story, what he calls a vessel of history, a, a meditation on memory, loss, and community.
And I have seen Mr. Winston's art. It's striking and wonderful. He is also not a newcomer. His complaint lists collaborations with Nike, Adidas, even multiple NBA teams. In fact, the Cleveland Cavaliers commissioned him to create a grid composed of 168 flattened basketballs that are now displayed at the Rocket Mortgage Fieldhouse, alongside works by Cause and Shepard Fairey. Shepard Fairey is the obey motif we see around Los Angeles.
I had a chance to meet Shepard Fairey once.
Did you?
Yeah, I have some of his works in my office. I was for a period of time on his Christmas card list, and he would send really unique pieces for the holidays. It was really super cool. We got to do it. One of my clients did a deal with him, and it was a blast, actually.
He's legendary.
Yeah.
Mr. Winston, for his part, he's been featured by the New York Times, Slam Magazine, and also Hypebeast.
Where did you see his work?
I've not seen it in person. I only saw it
Oh,
online.
got it.
But
Okay,
it's compelling.
got it. Well, maybe you could talk to your client. This should probably be a piece of art for their arena.
It would fit in perfectly, but we just obviously, in light of what we're about to talk about, need to be a little careful.
Yeah, for sure. All right. So, okay, so let's get back into this. Enough banter. So, Winston's aesthetic is widely recognized and it is strongly associated with him. His lawsuit claims that in September and October of 2024, the New Orleans Pelicans posted images to their official Instagram account showing an installation consisting of deflated basketballs arranged in a grid pattern, a work that is substantially similar to Winston's iconic art. That's alleged in the complaint. All right. So Winston holds registered copyrights for 2 works, and both of these works depict his signature deflated basketball grids. He claims that the Pelicans display is substantially similar to those works and that the Pelicans work infringes his exclusive rights under the Copyright Act.
Right. According to the complaint, the Pelicans' work copies several protectable elements of his work. Those elements are as follows. The distinctive grid-based composition of deflated basketballs, the intentional deflation of each ball to mimic the aesthetic of Mr. Winston's artwork, the matching color palette, which together create the distinctive worn monochromatic effect characteristic of Mr. Winston's artwork, the deliberate selection of similar brands of basketballs, the juxtaposition of worn sporting objects in a fine art presentation, the spatial arrangement and negative space between the objects, the framing used to present the basketballs on a vertical surface, the precise uniformity of the grid, despite the organic wear of each ball, and the overall visual impression, including the evocation of urban life, nostalgia, and cultural commentary.
And according to the complaint, a few fans actually believed that the Pelicans' work was his work. The complaint notes that several individuals commented under the impression, meaning the Pelicans' social media post, that the infringing work was artwork created by Tyrrell Winston. All right. So now that he's filed the complaint, let's talk about what the Pelicans will argue in response to the copyright claim. Because I think this part is the interesting part. We already have a bit of a peek into this. The Pelicans have already moved to dismiss Winston's case based on jurisdictional and venue issues. But in their motion, they basically explain what they eventually intend to argue concerning Winston's copyright claim. The Pelicans basically say that Winston is trying to claim ownership over a concept, the idea of deflated basketballs arranged in a grid, not a specific protectable expression. Copyright law has long held that ideas, styles, and concepts are not protectable.
Exactly. The Pelicans say that the infringing social media posts only share the concept of deflated basketballs arranged in a grid, and that this is an unprotectable idea. If the court were to accept Winston's claim, it would grant him a monopoly over an artistic concept.
Right. So the NBA cited a copyright case in that preamble portion of their motion or introduction or whatever you'd like to call it, because they never moved on that ground. This case is Morford versus Caitlin, I believe. And this is, I think, affectionately known as the banana artwork case. This
Right.
case is where one artist was suing another artist for copyright infringement over artwork comprised of a banana taped to a wall with duct tape. This is true, Richard. I am not making this up,
I
right?
know.
The crazy part about this, right? It's not that the two artists suing each other or the one artist suing the other artist. The crazy part about this is that somebody bought the allegedly infringing work for, I think it was like $150,000 or something. And that's probably what caused the lawsuit, is because the plaintiff got pissed off that this other artist taped a banana to the wall and sold it for 150 grand. Okay.
Right.
In the court's holding on the motion to dismiss in this case, Morford versus Caitlin or Catalian, whatever it is, the court held that no one can claim a copyright in ideas. So Morford cannot claim a copyright in the idea of affixing a banana to a vertical plane using duct tape, nor can Morford claim a copyright in bananas or duct tape.
Got it. But but Scott, arguing the other side, don't you think that Wilson's complaint explains his expression of the concept of deflated basketballs in a grid?
I mean, that's ultimately for the court, right? That part of the complaint where he talked about the expressive elements that were infringed. I mean, he did go to great lengths to address a number of issues, a number of points which he believed reflect the expressive elements of his work that were infringed. But consider this. If Wilson could have a monopoly over the grid arrangement of deflated basketballs, well, he could then also obtain a monopoly over other arrangements of deflated basketballs in various shapes, right? You know, whether that be triangular or hexagon or whatever, right?
Mhm.
Thereby giving him essentially a monopoly over this artistic concept of deflated basketballs arranged in some manner. Um, this brings us all the way back to another recent case that we previously discussed here on the briefing, not with you, but another host.
Mhm.
Um, Sidney Nicole versus Alyssa Shield. In that case, the Western District of Texas adopted a ruling recognizing that one influencer could own a copyright in her look, this so-called clean girl aesthetic or this beige vibe. The court held that another creator's videos, while not literal copies, were too similar in vibe, tone, and composition to escape liability.
And that's what made that case so controversial. It arguably extended copyright protection to style or vibe, not specific content.
Right, right. And that's the tension here. Winston's claim, while rooted in a registered work, essentially asked the court to treat his style of deflated basketball grids as protectable expression. If the court agrees, it could represent another step towards what critics are calling vibe copyright protection for the feel of artwork, not just its literal form.
But that comes with a risk. If the courts start treating artistic styles as protectable, we could see a chilling effect across the creative industries. Artists, brands, designers, they often work within overlapping aesthetics, especially in areas like conceptual art, fashion, and street culture.
Exactly.
So, if Winston prevails or even survives the inevitable motion to dismiss on the copyright claims, it could set a precedent that expands the boundaries of what's considered protected expression.
Right. And that could empower artists to more aggressively defend their stylistic identity, especially when brands use this aesthetic for commercial gain. But it could also make art direction and branding more legally risky.
There's also a fairness argument here. Winston isn't claiming he owns the idea of basketballs in art. He's saying that the Pelicans copied his execution so closely that fans literally mistook their work for his.
So I will agree that this is a persuasive narrative for a jury, but I will say that just because Winston may have been the one to successfully commercialize this style and type of artwork doesn't necessarily mean he's entitled to a monopoly over it. This is something we tend to see with cases on the edge where courts are grappling with whether modern creativity, where concept and style are intertwined, it can present a challenge for courts to sometimes distinguish the idea versus the expression.
So, Scott, do you think Winston's claim survives?
I think it's going to be a really close call. Courts are typically reluctant to protect artistic style, but Winston's registrations, his prior collaborations with NBA teams, the detail of the elements allegedly infringed in his complaint, and the public confusion over authorship, and maybe, you know, tie that in with the recent protection of vibe and aesthetic style copyright protection, maybe he just has enough to get past the motion to dismiss. I don't know that he should, but he may.
Yeah, it'll be interesting to come back and revisit these issues when they get to the merits of the copyright claim. And we'll just see how much this concept of vibe has taken root in the copyright jurisprudence.
All right, absolutely, Richard. We'll definitely come back and talk about this again. So,
Love to.
thanks to my co-host, Richard. Always great to have your insights. We'll have you back if and when, well, if this case doesn't settle and when the Pelicans eventually do file their motion to dismiss his copyright claim. And thank you, our listeners, for joining us on the briefing. If you found this episode helpful or interesting, please take a moment to subscribe, like, and share it with your network. We'd also love to hear from you. Please leave us a comment or a review and let us know what topics you would like us to cover in future episodes. I'm Scott Hervey. I'll see you next time on the briefing.